Housing is a human right. International law states that people in Canada should be able to get good housing that they can afford. In Ontario, the Human Rights Code applies to both tenants and landlords. Everyone has the right to equal treatment in housing without discrimination or harassment. Landlords are responsible for making sure housing environments are free from discrimination and harassment. People cannot be refused an apartment, bothered by a landlord or other tenants, or otherwise treated unfairly because of their race, color, ancestry or ethnic background, religious beliefs or practices, marital status, including those with the same-sex partner, place of origin, citizenship, including refugee status, family status, age, including individuals who are 16 or 17 years old and no longer living with their parents, disability, sex, including pregnancy, gender identity or gender expression, sexual orientation, or because they're in receipt of public assistance. The right to equal treatment without discrimination applies when renting a unit or buying a home. This right also applies to choosing or evicting tenants, occupancy rules and regulations, repairs, the use of related services and facilities, and the general enjoyment of the premises. The Ontario Human Rights Code says what can and cannot be asked when choosing tenants. Rental history, credit references, and/or credit checks may be requested. However, a lack of rental or credit history should not be viewed negatively. Requesting employment history of newcomers can result in systemic discrimination. Landlords can ask for income information, but they must also ask for and consider it together with any available information on rental history, credit references, and credit checks. Income information can only be considered on its own when no other information is made available. Income information should be limited to confirming that the person has enough income to cover the rent. Landlords can also ask for a guarantor to sign the lease, but only if the landlord has the same requirement for all tenants, not just for recent immigrants. Unless the unit is subsidized housing, it is illegal for landlords to apply a rent-to-income ratio. An example is a 30% cutoff rule where the rent is 30% of the tenant's income. Landlords have a legal duty to accommodate legitimate needs based on code grounds, such as disability, family status, or creed, and landlords must accommodate to the point of undue hardship. The tenant and the landlord share the responsibility of making the accommodation work by working together to solve problems and by providing necessary information. The code does not apply to personality conflicts between the tenant and the landlord, or between tenants that are not linked to the code. If you find your housing rights are being violated, you can contact the Centre for Equality Rights in Accommodation, CERA. You may also contact the Human Rights Legal Support Centre,